Thanks so much for tuning in. This is attorney Matt Wayman here to chat with you today about docket entries. The first one we're going to talk about is a counsel status hearing. What happens at a counsel status hearing is that attorneys go up in front of the judge and just apprise the judge as to the status of the case. So I would get up there and say something like, Your Honor, we have received the discovery in this matter. We're just waiting on a recommendation. And then the state would get up there and say, Your Honor, I'm just waiting on a recommendation to get approved by my supervisor. We should have one back in a couple weeks. The judge will then set the case on next month's docket so we can come back and tell the judge the status of it. The next one we're going to talk about is a disposition setting. Generally what happens is that at this setting is either you're pretty close to a plea, so you would just get a plea date from the judge, or if you don't have a plea agreement worked out by this point, then the judge would just set the case for trial. So it's disposition or setting for trials, what happens at a disposition setting. A plea setting is where you would actually go in front of the judge and withdraw your plea of not guilty and enter a plea of guilty. So it's where you enter a plea at the plea setting. A trial docket setting is where you think that a case is probably working its way towards trial, but you don't actually have a solid date for a trial, so you would just go in front of the judge, and the judge would tell you what dates he or she has open for the trial, and you would agree on a date so that everybody can start getting ready for that date for the jury trial or bench trial. A preliminary hearing is a hearing where the state has to put on evidence to establish probable cause that a crime was committed. So they would put on, police officers, they would put on any witnesses to establish a probable cause. It's a relatively low bar, but it gives the defendant a really good opportunity to see the strength of the state's case against him or her. A pretrial conference, that happens before a trial. It's basically where you would litigate any pretrial motions, any motions to include or exclude any evidence. Sometimes you'd go over jury instructions at a pretrial conference. You would talk about how many jurors you're going to need, maybe get the juror book, but it's everything that happens pre-trial. It usually happens about a week before trial. The last one would be a jury trial setting, and that would start off on a Monday generally with a jury selection, and they would move forward on a Tuesday or later that day, Monday, with an actual jury trial. So a jury trial setting is when your trial starts. The last thing that I want to just take care of is I just want to apologize for this hair. Sorry about that. Thank you guys so much for tuning in. We'll be back soon with more videos.